Hello, everyone. Thank you for joining today. My name is Frank Vitale. I am an executive director at Citrin Cooperman, and we are excited to have our esteemed panelists with us today to kind of give a overview and some insight on financial and estate planning and family planning for the LGBTQIA plus community. As we approach Pride Month, personally, this is really exciting for me. I am a co-leader of Citrin Cooperman's Employee Resource Group, CC Open, which is, again, to promote and support inclusion of the LGBTQIA plus community, both internally within the firm and externally out in the markets with our clients and referral sources, et cetera. So before we begin, I would like to, just go around and have the panelists briefly introduce themselves, and then we'll get the program started. We want to start with Mary.
Okay, thank you, Frank. Hi, everyone. I'm Mary Delman. I am a partner and co-leader of the Trust and Estate practice at Citrin Cooperman. I also co-lead CC Edge in New York City, which is our diversity, equity, and inclusion committee here at the firm.
Lisa?
Good morning, everyone. Pleasure to be here with all of you today. My name is Lisa Neira. I am a wealth advisor at Corient, which is a registered investment advisory firm. We have 32 offices across the country and manage about 150 billion in assets under management. I personally sit in the Morristown, New Jersey office. Sometimes you'll see me in the New York office from time to time. Aside from my day job of being a wealth advisor, I am also the co-chair of our DEI committee and run an LGBTQ plus specialty practice with a partner at my office.
Great. And Bill?
Good morning. My name is Bill Singer. I'm an attorney in Somerset County, New Jersey. For the last 50 years, I've been helping people create families which fall outside the accepted models. I have pushed courts to recognize the reality of children's lives and to make the laws fit their reality. I pushed legislators to create laws to protect new models of family. And once created and respected, I've helped protect those families through life and estate planning documents.
Excellent. Why we're so excited about this panel discussion and having these panelists is we want to really stress the importance of working with all of your advisors from a tax perspective, a legal perspective, and a financial and wealth management perspective. In order to properly plan for your family and preserve your wealth for the next generation within the community, understanding all aspects of what goes into it is really important, and working with your team of providers is really going to be in the best interest of you and your families. So with that, we'll get started. And Lisa, why don't we kick it off with you? And the first question, can we start off with briefly explaining what an estate plan is compared to a financial plan, and highlight some similarities and differences that the folks on the call should be aware of?
Sure. Thanks, Frank. So, to start us off, and really to be clear, anyone with assets, so that's a bank account, savings, stocks, bonds, a home, anything of value, kids, right, our children, likely need an estate plan and a financial plan. To what degree is going to depend on many factors. Today, we're here to talk about the similarities, but also the unique considerations for the LGBTQ community. And so to set the table for today's conversation, I'll explain in detail what a financial plan is, and also what an estate plan is and how they sort of interact with each other. So as a wealth advisor, I build financial plans for my clients. And what we do is pretty similar to that of an architect. So, except we're financial architects. What does an architect do? Well, she understands your vision and goal for the home. She outlines a blueprint and ultimately helps you build that home. And over time, you might need that architect to come back to maintain or renovate that house for you as things change. Now, a home has many critical components. It has a living room, a bathroom, a kitchen, a bedroom, all that make up what a home is. Now, imagine your investment portfolio, your risk management and insurance portfolio, your tax strategy, your retirement income plan, your estate plan, as some of the rooms of your financial home. And so just as every home needs a well thought out bedroom or kitchen, every comprehensive financial plan necessitates thoughtful strategies across these different areas or across these different rooms. And so with that, I think it's important to recognize that an estate plan and a financial plan are not two separate discussions. In fact, they work in concert together. At a high level, a financial plan is really a flexible blueprint for how you're going to reach your goals across your life. And it also acts as a guide to making smart, intelligent financial decisions, both today and for the future. And so I always say when I'm working with a client, especially to start, that the financial plan is going to do two things for us. It's going to give us visibility into how you stack up against your goals. So that's identifying areas of opportunity and potential risks. But number two, it's going to address those what ifs, right? Because life is, at least for me and many of my clients, is a bunch of what ifs. And there's a ton of them that come along with money, retirement, kids, spending money, and generally navigating the many financial milestones that we face over time. What a financial plan is not, it's not one conversation. It's not a binder report saying, hey, here you go, we figured it out for you, go on your merry way. Why? Well, life is a bit funny, and it's going to throw some curveballs at you that could change your financial life, whether it's intended or not. And so a plan is really designed to insulate you, to help with guardrails, to help you navigate your financial life a bit better, but also be better prepared for the unexpected. So what does a financial plan include, or what are the different rooms, so to speak? Well, it's going to address all areas of your financial life and can have varying degrees of complexity. And so a financial plan is going to touch on taxes today and the future, retirement planning and recreating that paycheck, legacy planning for the next generation. It addresses protection for you, for the things you own, for the people that you love. It'll help determine appropriate investment and proper asset allocation. And guess what? Financial planning is a family affair oftentimes. It encompasses family planning, college planning, and all that comes with having children. What I can also tell you is that not all financial homes look the same. So for our community, the LGBTQ+ community, there's a lot more to consider when it comes to growing the family, such as costs or the different paths you can explore, and certainly the legal considerations. So you can see that there's a ton of moving parts in a financial plan, and they're going to interact with each other and evolve with you over time. I'll give you an example. Your insurance needs might change as your debt levels change, or maybe you have kids and grow the family, or perhaps your investment portfolio needs attention based on your changing tax status. So let's talk about one of the most important parts or most important rooms of your financial home, which is your estate plan. Okay, and an estate plan is something that hugs your financial plan with protections and clear instructions for what you want to happen when you become incapacitated, God forbid, or pass away. And in some cases can help with minimizing taxes. I think everybody on this panel will agree that an estate plan is a really critical component of a really thorough financial plan, because it outlines really important instructions. Bill is going to talk about specific documents, but generally an estate plan addresses who can make health and money decisions for you when you no longer can, who will handle your estate when you pass, who will inherit your money, and who will be guardians of your children if that's applicable. A financial plan without an estate plan, to me, is just another liability that can come with pretty ugly pitfalls. And for our community, which we'll talk about today, why it's so important to make sure these documents are in place so that you control what you want to happen versus leaving any decisions for the courts to decide for you. Lastly, which we're going to talk about next, is an estate plan can address minimizing taxes, which I know we're all interested in, so that you can preserve and maximize more of your wealth for you and also for your family.
Great, thanks, Lisa. A big component of estate planning, or using Lisa's analogy, a portion of the room of the estate planning room, Mary, is proper transfer tax planning. Yep. Can you explain the basics of transfer tax planning and how it may differ for married versus non-married individuals?
Sure. So to build on what Lisa said, my role in the estate planning process is on the tax side. I'm an attorney, but Citrin Cooperman is an accounting and advisory firm. So we are helping our clients do their estate planning from the tax side. We want to help them plan their estates to be tax efficient. But there's a balance. You want to plan these estates for minimum tax exposure, but you also want to make sure that assets are being distributed according to one's wishes and people are comfortable doing what they're doing. We never want anyone to be in a position where they're just planning for taxes, but it's not carrying out their wishes and they're not happy with what they're doing. There needs to be a balance between the two. And that makes a very successful estate plan. And that's why you have all of your advisors in the room helping you from each side. So when we're talking about transfer tax planning, we're dealing with 3 different taxes. We have a gift tax, we have an estate tax or an inheritance tax, depending on the state that you're in. And we have generation skipping transfer tax. So I'll just go over this briefly. The gift tax is a tax imposed when you make gifts during your lifetime. The estate or inheritance tax is a tax that's imposed when you die. It's a tax on the fair market value of your assets at your date of death. The estate tax is a tax imposed on the estate of the person who passed away, and the inheritance tax has to do with who inherits those assets. And depending on the state, the rules vary slightly. There's also the generation skipping transfer tax, which is a separate tax from these two, but it works in conjunction with the gift and estate tax. So the generation skipping transfer tax is a tax on transfers to someone who is 2 or more generations below you. So if you're looking at a family relationship, it's a gift from a grandparent to a grandchild. The IRS wants to make sure that when you're skipping that child generation, they're still getting that tax, because they want to make sure they're getting a tax on every generation. So simplifying it, but that's why we have the generation skipping transfer tax. So when you're planning, when you're doing your estate planning from a tax perspective, you want to consider several factors. The size of your estate. What is your net worth? And it's not always easy to come up with these numbers, but an estimate is good. We can work with estimates to do that planning. The types of assets that you have. Are you liquid? Are you illiquid? Can assets be transferred? Some cannot be transferred. Your family structure and the family dynamics. You know, do you have good relationships with your family members, your children, spouses, significant others? You know, are you in a situation where there might be a divorce? So you need to be careful with how these, you know, the planning goes there as well. You also need to take into account state tax laws, because every state has different tax laws or just different laws in general for estate and gift tax. So you need to consider that as well. And as far as married versus non-married individuals. So the differences are for your estate and gift tax. Married individuals have an unlimited marital deduction. And when I'm speaking about this, I am assuming that we're talking about US citizens and residents, because the rules are different if you're dealing with people who live out of the country or if you have spouses who are not US citizens. So just want to be clear on that. So you have an unlimited marital deduction. Well, what does that mean? That means that if you make a gift to your spouse, there's basically no tax. You're getting a deduction equal to the value of that gift. The same as the estate tax and inheritance tax as well. When you transfer assets at death to a spouse, you're getting an equal deduction for the value of those assets. You'll have no tax to. Now there are some nuances to it, but generally that's how the unlimited marital deduction works. If you're not married and you make a transfer to a partner or significant other, you don't have the benefit of that marital deduction, but we do have a lifetime exemption, which is $13.6 million right now. So, and this is at the federal level. So you can transfer assets to someone else and use up to $13.6 million and not be subject to tax. Now, this lifetime exemption, it accounts for the gifts that you made, and it also accounts for the value of your assets at death. So if you've used some of that exemption during your life, it's going to reduce what is available at death. So just keep that in mind when you're planning. Just a few more things. We have gift splitting. If you make gifts to an individual, to a third party, and you're married, you can split that gift and treat it as made one half by you and one half by your spouse. One thing I want to mention about the generation skipping transfer tax, because I've had some awkward conversations with clients about this. So when we say a skip person is like a grandchild, that's when you have that family relationship. If you don't have the family relationship, the rule is if someone is 37.5 or more years younger than you, they will be in that skip bucket. And I've had conversations where a client is in a relationship with someone, they're not married, but they're in a relationship with someone who's significantly younger. So they're treated as being in that skip generation, and there could be that additional tax. So something to keep in mind as well. And Also, I'll leave this to Bill to elaborate on also, but on the legal side, when you're married versus not married, there's also how assets are titled, and there's some benefit to being married. Assets can be titled with right of survivorship and different types of titling. So that's something else to keep in mind as well.
Excellent. I just recently got engaged, and I should have included in my proposal how we would eliminate tax when we passed on.
There you go.
I don't know how that would have went over, but we'll see. Bill, a lot of great information, but everything obviously has a legal slant to it, and really understanding the legalities of everything is going to be an important part of our conversation today. So can you provide some insight on an estate plan from a legal point of view, and then also give us some thoughts of the different players and fiduciaries that kind of come into the picture from a legal perspective?
So many people think that an estate plan sounds like some very sophisticated thing that they don't need, but we all need estate plans, because a will does not necessarily cover the disposition of all of your assets. If you have a life insurance policy, the beneficiary named with the company is going to control where that money goes. The same for retirement plans. So it would be malpractice for me to put in your will that you leave your IRA to X, because if you've named Y with the company, it's going to Y. So the idea of the estate plan is to have a will and all of these other assets that are what they call non-probate assets, because they don't go to the will, make sure that the plan is coordinated among all those assets. And there's a key element here for tax efficiency. For example, it may be better to leave potentially high taxable assets to a charity if you have some charitable intent, and leave taxable and less taxable assets to people. So basically, we're talking about that there are 4 separate documents that I do for clients, for all clients, married, unmarried, gay, straight, it doesn't matter. The first one obviously is a will, which can also include what's called a revocable trust, which is a little more complicated. We're not going to go into, but you need a will that's going to provide what's going to happen at your death, and where your assets are going to go, and how things are going to be handled by the fiduciaries that we're going to name. And I'll talk about the fiduciaries in a moment. And then there are 3 documents that we do that are really pre-death. We call them living documents for while you're alive. So there's a financial or business power of attorney. And if you became unable to manage your affairs, or you're really just out of the country at a time, or whatever, this is a document that allows your agent, and we normally name an alternate as well, to deal with things like bank accounts, brokerage accounts, automobiles, real estate, your digital assets. That's a hot new topic, as we all have these digital assets and we really don't consider what's going to happen to them. So that's a financial power of attorney. Then there's a medical power of attorney, also called a Proxy Directive. This is not an end-of-life document. This is a document that says, if I am unable to speak for myself, I might be getting better, but I'm in the middle of an operation, or I come into a facility unconscious, this is the person that I want to make decisions as to who my doctor will be, what facility I will be in, what medicine I will get, who can visit me, things of that nature. And then the 4th and final document is the living will, which is the end-of-life document, where you name an agent and an alternate. And again, only if you're unable to speak for yourself, they can speak for you. So you're brain dead, permanently unconscious, suffer from an irreversible fatal illness or disease, or have no expectation of a meaningful quality of life. Under this document, you are giving your agent the right to withhold what they call heroic measures, like surgery, antibiotics, resuscitation, artificial administration of feeding and fluids. When I say to my clients, and the people that are listening today, because we are not recognized and respected necessarily by all the people that we think should respect us, that think about you're in an emergency room at midnight in a hostile state. That's what you really got to think about. And that's what you want these documents to provide, that you will be covered in those situations. So there are basically three fiduciaries that we name in these documents, particularly in a will. So what's a fiduciary? A fiduciary is a person or an entity, if you name a corporate fiduciary, that acts on your behalf as a duty of good faith and trust, and they're bound legally and ethically to act in your best interest. So there are three fiduciaries. I'll go with starting with the one by length of time. So you name an executor in your will. That's the person who's to carry out the instructions of the will, to gather your assets that go through the will, inspect and pay any claims against the estate, file your final tax return, file state and federal estate and inheritance tax return, prepare an accounting of everything that happened during the administration of the estate, and when that accounting is approved, to distribute the assets among the beneficiaries. That generally is a 2 to 3 year job. Please make sure that whoever you name is going to be able to do the job. You know, we ask our best friend, oh, would you be my executor? And they say yes, because like everyone, they don't expect that you're going to die. But we're all going to die, but they don't expect you're going to die. And then all of a sudden some tragedy happens and they're the executor. And well, they have their own life, their own job, their own kids. And being your executor, you know, becomes a second or third place priority for them. The people that are going to be hurt by an executor who does not do the work are the beneficiaries. So if you have kids, you know, that are going to be dependent on the assets being properly handled for them, and you name an executor who doesn't have the time for it, your kids are going to be the ones who will suffer. Executors are entitled to be paid. There are state statutes that lay out how they're paid. So it's not like you're asking someone to do this for free. The executor is doing a job, and they're going to have to pay income tax on the executor's commissions that they get. The next in length of service is the guardian. That's the person who's going to have the oversight of a minor's person and property. And that lasts until age 18, when the minor is considered an adult. Now, in most of the documents I prepare, I make special recognition that most kids at age 18 are not ready to take over everything as adults and are still depending on the guardian. You know, they come home for summer vacation or Christmas or whatever. So I make sure that even though the person is no longer officially a guardian, that that the expenses are paid. And the whole idea is there that you don't want the guardian to suffer any financial disadvantage for taking care of your kids, and that there is money to pay for that through the trust or through the will. And the final fiduciary is a trustee. If you create a trust, you will need to name a trustee. And there are all different types of trusts. There's the trust for minors, as I've just talked about, but there are also life insurance trusts, educational trusts, generation skipping trusts that Mary alluded to. And so you're really going to have to give some consideration of the pros and cons of who you're naming as trustee. Basically, there are two categories. There's a corporate trustee or an individual trustee. So a corporate trustee, they're professionally trained and they know how to professionally administer a trust. And that's an important quality. They're also subject to more government regulation as a trustee than an individual would be. One of the cons might be that they're not familiar with the dynamics and information about your family. You know, they're just one of many trusts that they're managing, and so that is something to consider. Also, trustees don't like handling unusual assets. If you have unusual assets in your portfolio, for example, a small business, a successful small business, but needs to be run, a professional trustee doesn't want to be running a business. They don't want to be holding large pieces of real estate and other what they call non-conforming assets. Another disadvantage potentially of a corporate trustee is personnel turnover. When you setting up the trust, I always tell my clients, if you're going to name a corporate trustee, interview them and find out, how they work, what they're, and make sure you feel comfortable with them. But, people change jobs, companies get merged with other companies. All of a sudden, the home office goes from Short Hills to Minneapolis. It's something to consider. Also, corporate trustees obviously have a whole fee schedule, and they deserve to be paid. Now, an individual trustee, hopefully you would name somebody with knowledge of your family. But at the same token, if you name like one child to be the trustee over the money that's going to be handled for other children, there can raise tension and conflict within the family, which you might want to avoid. And also, there's all that family baggage that comes along. I see a lot of siblings, after their second parent dies, arguing over things that happened during their childhood. They're reliving their childhood. You did this to me, and now you're doing that to me. So that could be a reason why you might not want to name an individual who's in the family, but you can name an individual like an accountant or an attorney or some trusted individual, and they may be a better choice than naming a member of the family. If the trust is going to last through generations, through these generation skipping trusts, obviously an individual is not going to be around through generations. So you have to make that consideration and deal with issues of successor trustee and how is a successor trustee going to be named. There isn't a great deal of oversight by a trustee on a day-to-day basis, and you could have problems of embezzlement or poor choices for investment. The daughter is the trustee and her husband's going into a new business, says, you're only getting 3% on your money, loan me some money for my business and I'll pay you 10%. And then, of course, the business goes on. So, and there's no one really standing over the trustee saying, are you making the proper investment decisions? So this is something to be considered. And also, does an individual trustee have the knowledge and experience that a corporate trustee has? I mean, a corporate trustee, that's their business. So one of the solutions might be having co-trustees, having a corporate trustee and an individual, so you get some of the benefits of both. So,
Great. Bill, just a quick add-on question. How often can you change your designation of a trustee or an executor? What does that process look like? As you mentioned, or Lisa mentioned, life kind of throws different things at you, and sometimes relationships change. So how often should, what should they be doing in terms of reviewing that selection on a regular basis?
So I tell clients to think of their wills and trust documents as a 5-year plan. If something happens in the next 5 years, this is what's going to happen. But look at it every 5 years. Now, the wills that I do for young families that have trust in them and guardians and all of that, those wills could last decades. They're written in a general way. They cover, even if you have more children, what would happen. And what I normally see is only the times that we're changing those documents is they change who they want to be guardian or they change who they want to be trustee.
Great. Thank you so much. Lisa, just kind of sticking on some of the legal side, are there any specific U.S. estate or gift tax laws that folks should be aware of before and during their planning process?
Yeah, this is a hot topic. So I'll kick us off with some background, but also some considerations on the income tax side. And I know Mary, you'll cover some of the estate tax piece. So the law is known as the Tax Cuts and Jobs Act of 2017. And it included some pretty major changes to the tax code. In fact, I think it was the largest overhaul of the tax code in 3 decades. But not all of them are here to stay. So there's a number of significant provisions that are set to expire on January 1st of 2026. So what's changed and what's changing again? So here's a few. 1, the act lowered individual tax rates. So for example, what was the 39.6% tax rate dropped down to 37%. So these favorable rates today will revert back to the pre-2017 rates in 2026. All this to say is that tax rates will be going up. Number two is the standard deduction. The standard deduction will effectively be cut in half. But I'm not here just to deliver bad news, and not all things are icky. There are some things to look forward to. So we have the SALT cap, the state and local tax cap of 10,000. That's going to go away. That's a big yay, especially for somebody like me, who lives in a high property tax state like New Jersey. I love my state, but we have high property taxes. This is a big win for us. And number four is the mortgage interest deduction. So the suspension of home equity loan interest deduction, that's going to go away. So that's another yay. But also the mortgage interest can be deducted on the first 1 million in home mortgage debt versus the 750 that we have today. So you get the suspension of home equity loan interest going away, and then an increase on what you can deduct from a mortgage perspective. So one thing that we've been discussing with clients is how to take advantage of the favorable tax rates we have today. So for example, my clients in the 24% tax rate today, they're going to get jumped into the 28% tax rate come January 1st of 26. So when dealing with Uncle Sam, it's never about if you're going to pay the tax, because you will. Rather, it's about the control of when you pay the tax. So especially for my retirees, for example, Roth conversions or accelerating income tax at 24% could potentially make sense today and essentially save them 4% on tax by doing so. And whether you like it or not, the IRS at some point in your life is going to come knocking on the door and say, hey, you need to take out mandatory required distributions from things like your 401ks and your IRAs. And that could significantly drive up your tax liability at that time. And often it's too late to do anything about it when you're already there. So any ability to control how much you pay in tax is going to keep more money in your pocket. So I say that's a conversation worth having.
I just want to add to what Lisa said, is also if you don't take your required minimum distribution, the penalty is 50% of the distribution you didn't take.
Mm-hmm. Yeah. The highest penalty that the IRS imposes.
Yeah.
Interesting. Mary, in addition to what Lisa just mentioned, there are some lifetime estate and gift tax changes happening on January 1st, 2026. Can you provide a little bit more insight on those and how folks should be prepared?
Yes. So I mentioned briefly earlier the lifetime exemption, which is 13.6 million. Now, this exemption started out as 5 million, and in 2017, under this act, it was doubled and it became 10 million, and it has been indexed for inflation since then. That's how we get to 13.6 million. But it's set to disappear, as Lisa explained, with these other rules on January 1 of 2026. So if you don't use it, you're going to lose it. So we're encouraging all of our clients to take advantage of this increased exemption. I expect that when it goes back to where it originally was, it will be 5 million index for inflation. So it's probably going to be around 7 million. I'm thinking somewhere along those lines. But then you're losing, almost 6-7 million of exemption. And then if you have, spouses who are married, you're talking about almost 27 million combined. And that's a lot of money. So we recommend trying to do some gifting now, take advantage of that exemption. A lot of clients they're not comfortable making these large outright gifts. So what do we recommend for them? If they have minor children, maybe a trust where you can put the money away from them. It's out of your estate, so you can effectively use that exemption and all of the future appreciation goes outside of your estate. But you have a little bit of control over how those assets are distributed. The minors wouldn't get them right away. Maybe you could say at age 30, they get half of the assets. Age 40, they get everything. You might want to create a dynasty trust where it goes for grandchildren. So you have a lot of options with trust, and this way you're not just handing a lump of cash to your children. Another option is very common, what's called a spousal lifetime access trust, or a SLAT. So we have people who are married and they're not comfortable giving away all these assets because maybe I'm going to need them. I don't know, 5-10 years from now, maybe I need those assets. So if this trust is drafted correctly, the assets will be removed from the donor spouse's estate, but their spouse still has access to those assets. So the donor spouse gets access indirectly through their spouses. So that's been a very popular planning technique, Bill. I'm sure you see that quite a bit as well. And then there's also something called portability, and it's at the federal level. And what this means is the first spouse that passes away, if they have not fully used that $13.6 million exemption, whatever they have remaining can be passed on to the surviving spouse. You file an estate tax return, you make that election, and now the spouse not only has the 13.6 million, but they have, in addition to that, whatever was unused by the spouse that passed away. And the good news, there is some good news here. If you elect portability when the exemption is at the 13.6, you don't lose it when the exemption gets cut in half. So if you port 13.6 of the first spouse that dies to the surviving spouse, that 13.6 is theirs to use. It does not get cut in half. So that's on the right side of that.
So, you know, many of us are procrastinators, or time goes faster than we imagine. And before we know it, it's January 1st, 2026. How would you advise, when should you start doing these things? You know, knowing that January 1st is coming, 2026 is coming, what's the proper timeline to really do proper planning? Now.
And I tell you this because you see all of these people on this screen. You've got Bill and you've got Lisa and you've got myself. We all need to be involved in your planning. Okay, you need to know the tax side. You need to know the financial side, what assets are available, how quickly can they be made available. And then you have Bill on the legal side, drafting documents, putting wills and trusts in place. People are going to be getting busier and busier as we get closer to the end of 2025. So doing it now is my best recommendation. Even if you just want to think about it, start, just laying out a plan. Even if you put a trust in place, but you don't want to sign it yet, at least it's drafted, it's ready to go. You've identified assets that you could potentially, move into that trust. You've spoken to your financial advisor, like Lisa's saying, how long does it take to move these out? Some things can't just be switched, in an hour. It takes time. So plan ahead.
Great. Thank you so much. Okay, Bill, staying on the topic of existing and changing law, I believe we have attendees from not just the New York Metro region, but throughout the United States. What guidance can you provide to ensure that their planning strategy not only properly aligned with some of the federal laws that we've discussed, but really from a state and local perspective, any advice that they should be aware of from that side of things?
I think it's very important. You don't want to expose your family to insecurity, particularly at a time of crisis or emergency. So one of the things I really want to stress is that if you are in a family that doesn't follow the 1950s tradition of family, that you better make sure that you have secured parentage for both, or sometimes there's more than two parents. And do not rely on a birth certificate. A birth certificate is not proof of parentage. I mean, I was shocked to find this out. The people named on my birth certificate are not my parents. Well, the woman who gave birth, yeah, that's probably your parent, unless you did it under a gestational surrogacy contract. But the heteronormative presumption was that the person that was married to the woman who gave birth is the other parent. Well, if you have a lesbian couple that and the non-gestational, non-genetic spouse is put on the birth certificate, it's a mistake to rely on that as proof that you are a parent. There was a case in New Jersey, in Camden County, a heterosexual couple married. The woman was infertile and unable to carry a child. And they got an egg. They call it a donated egg, but not generally people pay for them. They got an egg. They used the husband's sperm to create embryos, and they transferred one of the embryos into a surrogate who gave birth. When the birth certificate was being issued, the wife said, "My name should be on there. I'm the parent." The Bureau of Vital Statistics disagreed. That case went to the New Jersey Supreme Court and ruled there are only 3 ways you can be a parent in New Jersey. And this is probably true in most states across the country. 1, You're a parent if you gestated the child, except unless you did it under a gestational surrogacy contract. 2, you're a parent if you contributed genetic material. Or 3, you have a court order or judgment. So in this Camden County case, the wife had to adopt the child because she did not gestate and she did not provide genetic material. Ultimately, what we're trying to do is make sure that your parentage will be respected in all 50 states. So you have the freedom to travel and the freedom to move. There's a provision in the United States Constitution that says full faith and credit must be given by one state to a judgment from another state. And we have an example of a lesbian couple that had an issue here. There's a lesbian couple living in Alabama that had 3 children, all with the same bio mom. They went to court in Alabama to fix the rights of the non-bio mom. Alabama court said, we don't do that here. The family picked up and moved to Georgia. While living in Georgia, they got 3 judgments of adoption naming the non-gestational, non-genetic mom as an co-equal legal parent. They moved back to Alabama. They broke up. The bio mom said to the Alabama courts, you shouldn't recognize these judgments from Georgia because you wouldn't do that in Alabama, and this non-genetic mom has no rights. The Alabama Supreme Court agreed. That case in 2016 was appealed to the United States Supreme Court, which ruled 9-0 that Alabama must accept the Georgia judgments. So we have a lesbian mom case from the United States Supreme Court that says if you have a judgment that says you're a parent, you're going to be protected and you can move freely from one state to another. So this covers judgments. A birth certificate is not a judgment. There's also something called a voluntary acknowledgement of parentage, a VAP, which every state has, where you can go in and sign and say, I acknowledge that I'm a parent. Again, that's not a judgment. The gold standard is getting an adoption judgment. Now, most of my clients hate the word adoption. What do you mean I have to adopt my own child? And I agree, but everyone knows what a judgment of adoption is. And you're in midnight in that emergency room in this hostile state, and they're questioning because you have a different last name than your child, and the bio mom, the gestational mom is not around. You'll have your judgment of adoption, and that will get you what you need. So my advice is to get it when you can and while you can. If you live in a state where you can get a judgment of adoption to fix your rights, do it. It's not necessarily available in every state, as just we saw in that case from Alabama. And there are plenty of cases around the country in all sorts of states where the non-gestational and non-genetic parent failed to act on their rights and they lost their rights to the child, as unbelievable as that may sound. In addition, if you are applying for government benefits, I had a client who said, oh, my name is on the birth certificate, that's good enough, and I don't need all this other expense and go through all this hassle. She got cancer. She went to Social Security to get disability benefits for her 2 sons. And they said, well, prove that you're their parent. And she pulled out her birth certificate. And they said, that's not good enough. So don't expose your family to insecurity. Do this when you can.
Great. And scary. The fact that there's so many things that we don't even think about when you are just living. And it's such an important message to make sure that we are prepared and legally protecting ourselves and our families. Mary, not everyone, life changes and folks sometimes want to move from one state to another. Are there things that, any advice you have on that, on how to prepare if you are planning a geographic move in the future?
Yes. So states have different transfer tax laws. We have 17 states that have an estate or an inheritance tax. We have one state, Connecticut, which has a gift tax. And so maybe if you're thinking of moving to Connecticut, you might want to make gifts before you move there. Or if you're in a state that has an estate or inheritance tax, maybe you want to make gifts so you're not subject to a gift tax. The trust laws also differ by state, and it's really hard to stay on top of it, but it's important to understand. Some states consider a trust a resident trust. It's determined by who created the trust. Some states, like California, they look to the beneficiaries and the trustees. So it's very important to make sure you understand all of these tax rules before you relocate. And also on the income tax side, when you're breaking residency, like if you leave, I live in New York, if you leave New York and go down to Florida, you need to have a plan to break that residency. It's very tough to break New York State residency, and New York will keep pushing. They want the proof. Like, they're not just going to say, all right, enjoy your time in Florida, no longer New York. They're really going to come. Like, you can expect an audit. If you say I'm no longer New York resident, you can expect an audit. You need to be prepared for it so you can beat that audit. So it's really important to look to the rules of the state where you're going.
Great.
Mary, I know I had a client who lived in Florida, went to visit her children in New York, and got ill and got put into a facility in New York and lived there for 3 years. And it became a question of what was her intention? Is she still a Florida domiciliary, or is now she a New York domiciliary?
Yeah. And I have clients who keep very strict day counts. I have a client who, lives in Florida but has a house in New York, and, very careful about how many days I step into this state, because New York will grab you.
Mhm.
So yeah, it's important.
I have a quick question actually for Bill on this, because my wife and I, we just traveled to Texas. We just got back this past weekend. And so with the legal documents you talked about, do you recommend bringing them, if we're traveling to, like you said, a hostile state?
I think you should carry all these on your handheld device, on your phone, so you can just pull them up. I mean, yes, you could bring the originals, but I think just having the electronic copy of all of these documents, your powers of attorney, your medical proxy, your adoption certificate, your marriage certificate, we got to arm ourselves. We got to protect ourselves. There's a lot of hostility to our community.
And if I can add to what Lisa just asked, I have three children in college, and before they all went to college, I was doing, they're all 18 now. They're of legal age. So I was putting in powers of attorney and healthcare proxies for each state. They were all in different states, but people don't think of that when their children get to be the age majority, then they have to have their own. You no longer can walk into a hospital and say, I'm the parent, I'll make the decision. And I made them all take these documents. I have a copy at home, and they all have a copy with them at school.
The issue that I've had, I think I agree with you, Mary, 100%. You need to do that. But then I've had the youngsters kick back. Well, wait a second. Does that mean that my mother's going to have access to all my mental health records? Can she find out that I had an abortion? I mean, so
Yeah,
it's tricky. And
it is tricky.
They come to me, oh, well, you're the family attorney, and I want this, but then I got, this conflict between the parent and the child, and
it's not easy.
no.
So Bill, you have, provided a lot of insight on what the queer community really needs to consider with regards to parentage. But let's go back to really, the origins of family, which are relationships, and how, so what are legal recognized relationships? Can you provide a clear definition of what that looks like for those of us who are maybe not officially married?
Sure, Frank. And thank you for using the word queer, because I prefer it. I mean, I know a lot of people have problem with it, particularly people my age, because it was such a pejorative term. But LGBTQIA.
It's a tongue twister. It's a tongue twister.
So it's queer just, so then my straight friend says, well, can't I be queer? I mean, I think queer is, pretty good. So anyway, same-sex couples can now get married in every state. Now, if Justice Thomas and Justice Alito have their way, that might change. But right now, we can get married in every state. But a lot of states have alternate forms of relationship recognition. Part of that is because we got relationship recognition over time, and a lot of that evolved where legislators said, well, we want to give same-sex couples some protection, but we don't want to give them marriage. So we have domestic partnership as one level of relationship recognition, and civil union. And that varies from state to state. New Jersey has both domestic partnership and civil union. In Illinois, they have civil union. In California, they have registered domestic partnerships. You know, so it depends what state you're living in, what's available. And the other thing to know is if you entered into a civil union in New Jersey, that's great while you're living in New Jersey. But if you move to Florida, Florida doesn't recognize that civil union, and all of a sudden your relationship, the recognition of your relationship is gone. And if you've done planning based on that your relationship would be recognized, you have to re-examine it when you move. These lesser forms, we'll call them a relationship recognition, do not come with any federal benefits except the survivor of a domestic partnership or civil union is entitled to survivorship benefits through Social Security. That's because it goes back to when Social Security went into effect in the 1930s. A lot of people were in what they called common law marriages. So Social Security provided that if you were in a relationship that was not marriage, but recognized under certain circumstances in your resident state, that you would get survivorship benefits. So, for example, you are in a New Jersey civil union and you move to Florida, you're no longer going to get survivorship benefits because Florida is your resident state and they don't recognize that type of relationship. And there's also a growing recognition slowly that people don't want to get married. And certain unmarried people should still get certain rights. So there are certain reasons to get married or not get married. Reasons to get married, and I go through this all the time with clients because so many of my clients have been together for years. And they're going like, you know, why do we need to get married now? We've been together 30 years, and particularly women of my generation who grew up in the women's liberation movement say, you know, I don't want to be part of that patriarchal, hierarchical construct. And, you know, I don't need a piece of paper to prove, you know, that I'm in this relationship. But reasons to get married would be that you can avoid federal and state estate and inheritance taxes, and that's state specific, as was pointed out. You get much better treatment of an inherited retirement plan if you are a surviving spouse. There are asset protection features that we've discussed, ways to hold real estate or other assets, as they call it, tenants by the entirety. That's an asset protection feature that's not available to the unmarried. And you get dignity and respect for your family. So a lot of my same-sex female couples who at first spurned the idea of getting married eventually did. And I said to one of them, well, how does it feel? And she said, I feel both freer and more secure being married. But there are reasons not to marry. If one person is receiving government benefits based on family income, if you're married, you could get, and you could lose those benefits because your family income is too high. I have clients who have large student loans, and their student loan payback is based on their income. And if they get married, they have a larger family income, and all of a sudden now their repayment rate changes and maybe not something that they can afford. I also advise clients, there's something called the adoption tax credit. And when I talked about you should get this an adoption while you can to secure your family, an adoption tax credit is not available if you are adopting the child of your spouse. But if you are not married, let's say you're in a civil union. I have clients, I told them, look, you're going to have 3 kids. You know that already. But we want to protect your family. Do a civil union that's not recognized by the federal government. And as you have their children, do your adoptions. You can take advantage of this adoption tax credit, which is $16,000. It's a credit against your income tax. So then you protect your family, and when you're done creating the family, then get married. Another reason that people don't marry is the marriage penalty. All of a sudden, now you're filing a joint state and federal tax returns, and you're pushed into a higher bracket. So that would be a reason possibly not to get married.
Great. And, just going back to your mention of domestic partnership and civil unions, in one of your previous examples, you mentioned the couple broke up. What happens in those cases? Do you, with a marriage, you file for a divorce? Do you have to legally separate a civil union or domestic partnership, or so you're not bound to it should something happen to the relationship?
You definitely have to terminate those relationships. And I get people who come into my office and say, oh, gee, back in 2002, my husband and I, we lived in Utah and we went to Vermont and we did a civil union. But we moved back, we were living in Utah, they didn't recognize it. And we broke up and we didn't do anything about it. And now I want to marry my new boyfriend. And I said, wait a second, you can't marry them until you terminate the first one. I hope you haven't paid the caterer already, because it's going to take some time. And so all of these things, even a low-level New York City domestic partnership, which really gave you no benefits, needs to be terminated according to the law of the jurisdiction.
Excellent. Thank you so much. I just want to point out, I did notice that there was a question put in the Q&A feature. I didn't mention that at the beginning. If you do have questions, we will be saving some time at the end to address those. So if you have a question, you could enter them in the Q&A feature, and we'll do our best to address all of those after we finish the content we wanted to make sure that you heard. Lisa, building on everything Bill just talked about, do you have a checklist or a specific list of things that individuals within the community should consider as they look to start a family or begin to start a family?
Yes. So I think this is so incredibly important to really stress the urgency of having these conversations with your partner and having them early. I mean, really, the minute you start seriously considering growing a family, start the discussion. There was a study done in 2019, and the bottom line is the millennial generation and those coming after them are growing their families at a higher percentage than ever before. Fun fact, 48% of the LGBTQ or queer millennial group, they're actively planning to grow their families compared to the 55% of non-queer millennials. That's a gap that's significantly narrowed. And of that group, 63% of them are expecting to use either assisted reproductive technology, which I'll refer to as ART moving forward, like IVF, or foster care or adoption to become parents. And each of those avenues is, a different component of time and money, and to varying degrees. So people really need to know their path and what's ahead of them. So let's talk about a checklist. First is know your legal rights and protections in your jurisdiction. So that's talking to somebody like Bill in your state. So that's understanding your rights related to adoption, surrogacy, parentage, custody, things of that nature. By the way, as you kind of heard today, keep Bill's contact, because you're going to have conversations once the child's here on guardianship, making sure you don't leave anything to court decisions, and ultimately protecting your partner's ability to step in, make decisions, inherit your wealth. Number 2, educate yourself. Educate yourself and choose the path that makes the most sense for you, whether it's surrogacy, adoption, or the various forms of ART that I'll talk about. Again, they all come with different costs, emotional journeys, and certainly time. So I recommend spending the time talking to professionals, doing your own research, get educated. Number 3 is financial planning. So knowing your options is one thing, but understanding the costs associated with them and having a plan is another. So we're going to talk about that next as well. And lastly, I would say as part of the checklist is consider a provider or agency that specializes in LGBTQ family planning services. So, for me specifically, my wife and I, we worked with an agency referred to by my friend and also the community to a practice and to a doctor that were clear allies and supporters of the community. So Frank, those would be my 4 important components of the checklist.
Right. And you touched on costs. So can we dive a little bit deeper into the costs associated in creating a family within the community, because it's not as easy as it sounds sometimes. And there's always, you know, I have a lot of friends who have gone through it, and sometimes I'm really shocked at the cost associated with just even getting started before you even have the family. Just to create the family is an expensive venture. So can we give a little bit more detail on what that looks like?
Yeah, certainly sticker shock there. So, you know, becoming a parent is expensive, and that's regardless of who you are or where you live. But for our community, that number can increase pretty significantly because of the cost just to bring a child into your family, not to mention the legal requirements to secure parental rights. You know, as an advisor, many of my clients, my heterosexual clients, have children or are planning to have children. And oftentimes the biggest cost when it comes to kids, and I mean large expenses, is typically for college. So we open 529 plans, custodial accounts to save for some of these larger big kid expenses. Now, for our community, again, we're facing heavy expenses just to have children. And when I was having these conversations with my wife, when we embarked on this journey, costs were a big factor, but so was the way in which we brought our child into this world. So let's talk about some avenues and some cost. First, you know, adoption, which can range up to a few $1,000s when you're adopting through the foster care system, but can go north of $70,000 when you're looking at private agency adoption or international adoption. Surrogacy generally can be a common pathway for men, and whether it's gestational surrogacy or genetic surrogacy, it comes with incredibly high cost. By the way, very quickly, the main difference between gestational and genetic is that with genetic surrogacy, the surrogate's eggs are used, making her the biological mother of the child, where gestational surrogacy, the surrogate has no biological link to the baby. So the cost is this: hold on to your seat, up to and sometimes north of $160,000. Yeah, take a second to take that in. Bill, very quickly, as the attorney on the panel, are there any other considerations legally specific to the genetic surrogacy?
Well, the advantage of gestational surrogacy is, of course, that the carrier is not genetically related, and in many states, including New Jersey and New York, California, you can get what's called a pre-birth order. So even before the child is born, you have an order from a court that's saying that the gay male couple are the parents from the moment of birth. They make all the decisions from the moment of birth. Their names are on the birth certificate. With a genetic, or it used to be called traditional surrogacy, the surrogate is the biological parent, and so therefore you have to do all your legal work after the child is born to terminate her parentage rights. In New Jersey, a woman cannot give up her rights as a parent until 72 hours after birth. And generally, though, you're going to have to go to court to have the genetic surrogate removed and have the second parent added as the second parent.
Yeah. So certainly some considerations there. Thanks, Bill. So a couple other paths, IUI, which is intrauterine insemination, which is it's a method of conception where the sperm, which is also not free in most cases, is placed through a catheter into the uterus, and it can be done at home or at a doctor's office. That avenue can range from a few $100s to a couple of $1,000s, and that varies based on success rates. By the way, sperm, I mentioned, is not free. So if you're going to a sperm bank, anonymous sperm, that can cost up to $1,500 per vial. And that could add up depending on if multiple vials are needed. And so then let's kind of shift gears to ART, or assisted reproductive technology. So I'll talk about two forms there: IVF, in vitro fertilization, which is where eggs are collected from the ovaries, fertilized in the lab, and which creates an embryo and placed in the uterus. So that could range with medication to tens of thousands of dollars, right? So you could be spending up to $25,000 plus, depending on, again, how successful you are. Subsequent attempts can cost anywhere in the range of $4,000 to $7,000. And then lastly, reciprocal IVF. This is the path that my partner and I chose, where we used my eggs to create an embryo, which was then transferred to my wife to carry and birth our child. So that makes her the birthing mother, and me also the biological mother. Now, this can cost anywhere between $15,000 to north of $20,000, because again, it depends on the success rate. So let's talk a little bit about how to plan for some of these costs. So another checklist for you. One, financial planning, right? Do some budgeting, understand your resources, your own resources sooner than later. So, and then work with an advisor to carve that path ahead on what you need to do to secure adequate funding. Number two, and Bill alluded to this, is the adoption tax credit. So for 2024, the adoption tax credit is $16,810. And the amazing thing about a tax credit is that it's not a deduction that reduces your income for the purposes of determining your tax liability. Rather, it's a tax deduction. It's a tax refund that's based on dollar for dollar reduction of your tax liability. So simply put, the adoption tax credit is $16,810 in your pocket to offset adoption costs. Now, there are some, it begins to phase out, for taxpayers with certain modified adjusted gross income above about 250. So there is just some considerations there. And again, this is, applicable for international or domestic adoptions, and you want to make sure that you're reporting this appropriately. If you're also eligible for employer adoption assistance programs, which leads me to my next piece, number 3, talk to your employer. See what benefits programs are offered, like the adoption assistance program. The next is understand your insurance coverage. We have lived and still live in a world where insurance coverage was written for heterosexual couples. So my wife and I, for example, when we were going through this process, we were not covered because we were deemed socially infertile, not medically infertile. Now, what I will say is more and more companies, and I would love to see this happen at a quicker pace, are adopting new standards of care to include greater flexibility for our community. In fact, in New Jersey, my state, our governor recently expanded health insurance coverage requirements for infertility services, regardless of sexual orientation. Bill, again, as the amazing attorney on the panel, are there any other legal changes that you're seeing? I think there was something with Aetna.
Well, all right. So as you mentioned, the legislature and the governor extended mandated coverage on insurance for infertility. It doesn't matter if you're married or single. If you are deemed infertile, and every taxpayer is infertile, no taxpayer can recreate on their own. It was a great advantage. Last week, there was a class action suit brought against Aetna because they said their policy discriminated because they gave infertility coverage to heterosexuals and not to people who fell outside of that definition. And Aetna agreed that they're going to change their policies. So this is happening across the country. Again, probably in states that are friendly to our community, you're going to see this more than states that are not.
Yeah, exactly. So again, hope to happen at a quicker pace. And then lastly, fertility financing companies is another avenue to explore to help finance the cost. The nice thing is that these companies coordinate directly with your doctor, your provider, for ease and convenience as well.
Also, grandparents. A lot of people want to become grandparents, and they become a fund to pay for some of these costs.
I should have you talk to my parents about that.
It used to be gay men, you tell your parents, oh, I'm gay, oh my God, I'm not going to have children and grandchildren. Now, at marriages, gay weddings, they're saying, well, when's the first kid coming? So, now it's expected that we're going to reproduce.
Yeah.
A lot of great information, Lisa. Thank you so much for being so detailed and transparent, even with your own story. So that's really appreciated. Bill, as conflict over transgender and gender non-binary individuals continues to escalate in this country, I don't want to, not include that in the conversation today. So can you provide, some steps that transgender and gender non-binary individuals can take today to start protecting themselves and preserve their rights and their wealth for themselves and their families?
Absolutely. The transgender and gender non-binary community are being exposed to this dehumanizing rhetoric and these punitive laws around the country. And it's very hard to see, that members of our community being treated this way. So it's very important that a trans or gender non-binary person have all their identity documents aligned as how they present themselves. So, obviously the first step there is a name change process. But you also need to get your driver's license changed, your passport changed, your social security information changed, your diplomas and school transcripts changed. So if an employer asks to see your transcript, that the name aligns with who you are and how you're presenting yourselves. The You can also change your gender marker on your birth certificate in some states. It used to be that you had to have gender change surgery in order to get your gender marker changed. Now in New Jersey, where I practice, they have done away with that surgical requirement, and it's now a self-attestation. You just sign a document that says, I attest that this is my gender, and we have 3 choices in New Jersey: male, female, and gender non-binary. So your birth certificate can say M, F, or X, and you can just do that through a self-attestation. Again, my advice is get it while you can. You know, you might be living in New Jersey and get it pretty easily, but then you move to Ohio and all of a sudden you can't. So it's very important that you do that. Changing a minor's name is a little more complicated, but can be done. And we're not asking a judge when they're changing the minor's name to consent to puberty blockers or some type of surgery. All we're asking is get your name changed. So I suggest that you do that. It's very important. And all of us, just let's be guided by the science and medicine and not by the rhetoric.
Excellent, and so important. And, you know, for our community and other members of our community, you know, there's such diversity within our community. So really understanding how each situation is different and understanding your own personal situation is key here. So you're taking the right steps to protect yourselves. Mary, Bill mentioned earlier about a will and, you know, how often you should be looking at maybe changing your trustees or your executors. What about from an estate plan perspective? What's your advice on how often should folks be looking at this? Are there trigger events that they should be focusing on? When should they, you know, give us a little bit of insight on how often and what might be a cause to review?
Okay, so I recommend that estate plans be reviewed frequently, updated when necessary, and some of the reasons that you may need to review your plan or update more frequently is maybe there's a marriage or a civil union or a domestic partnership put in place, and now you know you need to change it accordingly. Adoption or birth of a new family member. So maybe you have a will that never talked about, you know, who's going to take care of my children if something happens to me. So now you need to add that to your will as well. Death of a family member. Maybe you have someone in your executor in your will was, you know, a family member who's passed away. So maybe you need to revise that just to rename a new executor. You have a material asset value increase or decrease. You know, your assets are different than where you were 10 years ago or 5 years ago, even when you put that will in place. So maybe it's important that you need a will that's a little more detailed now, that, you know, puts a little bit more meat into there. You might want to reference specific assets versus just saying everything goes to this person or, you know, something like that. Educational funding. If you have children and you want to provide for education, you can put that, you know, revise those documents as well, set up trust. It's not just your will, it's the entire estate plan. So it could mean your will may not change, but maybe you want to put a trust in place or something like that, you know, as you go through life. Divorce is a big time to change these documents. You know, as Bill mentioned, you might have, you know, a spouse listed on your 401k as a beneficiary, and that doesn't pass under your will. And if you don't go and change that, then they're going to inherit your 401k. And also with children, when you have your 401k, you might list the spouse as the initial beneficiary, but then if they're no longer living, you need to list alternate beneficiaries. And as you have more children, you should probably add them all in there. You know, you have one, you put that one is getting, you know, everything, and then you forget to add the other ones, and that will cause a lot more problems with the kids. So make sure that you're constantly thinking about as you have these life changes. Business succession planning. You're getting older, you're close to retirement, and you want to start thinking who's going to take over the family business. Good time to start thinking about this plan as well. I mean, you might have a child who's interested in taking care of the business, and the other child wants no part of it, but you want your estate to be divided equally. So you might have to shift how those assets are going to be distributed to make sure everyone gets, you know, an equal amount. Gender transition, that's another time, you know, as Bill explained, to make sure that you're going through these documents again and changing what needs to be changed. And, finally, tax laws, as Lisa and I talked about, the Tax Cut and Job Act, doubled from the state perspective, the state planning perspective, it doubled that exemption. So we've seen a significant amount of planning that's happened since 2017, just to take advantage of that increased exemption.
Great. And Lisa, how about from a financial plan perspective? How often are you reviewing that with your clients, or do you recommend that your clients revisit their holistic financial plan?
So really there's two primary reasons. One, at a minimum, once a year with your advisor to just generally ensure that and see how you're tracking against your goals. That's almost table stakes. But I also mentioned earlier, life's going to be throwing those curveballs at you and things can change. And as Mary just mentioned, tax laws, estate laws can change that impact you as well. So that's when we'll go back to the financial plan to understand the impact to you specifically and determine, what changes we need to make at that time. So a financial plan, just like an estate plan, they're living, breathing documents, right? And they're going to evolve with you over time. So that's why making sure you're revisiting them as things change is going to be really important.
Okay, before we get to the Q&A, I see that we have a number of questions. I wanted to ask each of our panelists, we covered a lot today. There was a lot of information, and for everybody on the webinar, there will be a recording of this that we will send out, so you could access it at your leisure as well and clarify any things that you might have missed, etc. But before we leave, I want to ask each of the panelists, if you had one thing that you would recommend that everybody on the webinar remembered leaving today, what would that one thing or one piece of advice be? And last, we ended introductions with Bill. We're going to start with Bill on this question.
I just want to make the point that we're also creating family in many different ways. We have multi-parent families, we have polyamorous situations, we have intentional community, we have chosen family. We're working on broadening the concept of and protection of those families.
Great. Mary?
My recommendation is to plan now to use that lifetime exemption. Start now. I know a year and a half might seem like a long time, but you have to get all your advisors involved. You don't want to be making rushed decisions as we get closer to the end of 2025. And you don't want to be told by your advisors that I'm just too busy. I can't help you. So better to plan now.
Great. And Lisa?
Mine is fitting because I love to talk. So it's going to be communication and doing it early. So whether it's with yourself or with your partner, start thinking about what you want for your future self and then communicate with your advisors. It is never too early to start building your financial home. Just don't let it be too late.
Good.
Excellent. Okay, so we do have a number of questions. So we're going to do our best, we have about 12 minutes, so we'll do our best to address them. If we don't get to all of them, we will try to put together a Q&A kind of doc, and we'll have our panelists address any other questions that we could distribute with the recording to everyone who attended. Bill, this one might be for you. If you are a same-sex couple married in another country like Canada, will your marriage be recognized in the United States in all 50 states? And should you go ahead and get married again in your home state to ensure your marriage is recognized?
Your marriage will be recognized. You don't need to remarry.
Excellent. And Bill, you touched on this about how the community is vast and diverse. The question is, what is your advice for polyamorous unions or families? How should they be approaching their planning and protection process?
Well, as Mary and Lisa said, you got to meet with your planners and your advisors. You can be protected. I represent polyamorous families. I represent multi-parent families, and there are things that can be done. But you got, because you're sort of outside the box, you're stretching the envelope of what the definition of family, you got to work with professionals to protect them.
Some of these questions I felt we addressed. One was, at least until the outcome of the 2024 presidential election, how do we plan for the tax consequences of January 1st, 2026? I feel like we covered that in depth with both Lisa and Mary. Is there anything additionally that you think you would add to address that question?
I mean, we don't know what's going to happen with this, you know, these changes that are set to sunset. We don't know what's going to happen with the presidential election. So just start thinking now, even if, you know, if you want to wait to see how the election goes, that's great. But start thinking about what you would do in both circumstances, just so that you're prepared.
Yeah, I think one thing I'll say too is know how it's going to impact you, right? So, you know, talking with advisors, you can get a sense of, hey, when this law goes into effect or the changes happen, here's how it's going to impact your tax status and beyond. And so that'll give you some idea of some of the things that you could be doing today. So, you know, there are things you can do ahead of time. It's just, everyone's unique, right? Everyone has a different financial home. So you got to talk to an advisor to see how it impacts you.
There's another question about this being a political year and party leadership changing. And, you know, as Mary said, nothing has been proposed yet, but, you know, proposed tax plans do usually come out further along in this process. So you should be talking to your tax advisors as those proposed plans come out and see how they might impact you or how things might change. So you should be looking, and, you know, firms like Citrin Cooperman also, you know, distribute a lot of content on topics like this. So again, you could always reach out to Mary directly as proposed plans come out, and she could probably share a piece of content or an article that provides detail on what changes are expected should there be a party change in the White House. Here's a question. I am in Florida. My fear in adoptions is that the biological parent could always come back and state, I want my child back. And I know we touched on this a little bit, Bill. How do we secure ourselves from that issue? Is that an issue that we need to be concerned about? And
you definitely should be concerned about it. But in order to do an adoption, you have to terminate the parental rights of the biological parents. And that's done, you know, through a court action or under state law. So if you're adopting a child, you've got to make sure that the biological parents' rights are terminated, and then they are non-parents. They have no right to come back later and try and undo an adoption. I also try to stress to my couples that, you know, you're this a wonderful couple, and now you're adopting this child, and then you break up. That you can't undo the adoption. You know, you can't just change your mind and say, well, you know, one parent no longer wants to be a parent. You're a parent. It's irrevocable. It's forever, unless you terminate your rights.
okay. We are preparing to relocate to another country. How do we export our estate planning to other countries while retaining U.S. citizenship, at least in the short term?
I could take that one. So just be aware that there are tax laws here in the United States, but every other country and jurisdiction has their own sets of laws. They have different income tax laws, estate tax laws, gift tax laws. So if you're going to retain your U.S. citizenship, you're going to be taxed as a U.S. citizen no matter where you go. Income tax-wise, estate tax-wise, you will be taxed on your worldwide assets, wherever they're located. But be aware, and you will need an advisor in the other country that you go to. So if you go to France, for example, their estate and gift tax laws are very different from ours. So it's important that you have an advisor here in the U.S. and one in France. I always recommend having wills in both countries as well. And just making sure that when you're doing your planning that, and it's not always that easy, you can't always make it work on both sides. So you have to see which works out the best for you, but it's important to have advisors on both sides helping you out.
I'm going to just build on what Mary said. I agree with her. But you know, you should have wills in both countries. But you know, your U.S. will says it's about my U.S. assets, and your French will says it's about my French assets. And then if you later do another will, don't start out with I revoke all my prior wills, because because that will, you know, you're not trying to revoke all your prior wills. Maybe you're just revoking your French will. So it's important to do that. And also, although we have trust in the United States, other countries don't recognize trust in the same way. So it's an intricate and sophisticated planning.
Excellent. Bill, this one's probably for you. For second parent adoption, or maybe Lisa as well, is it financially beneficial to wait until you complete your family or do it after each child's birth? So,
go ahead, Lisa.
Bill can fact check me on this, but I would say after each birth, you go, you meet with somebody like Bill, and you get the documents drafted.
And you know, in New Jersey, we've streamlined this process. We now call it confirmatory adoption. And if you're a married couple and both your names are on the birth certificate, as long as you can prove that no one else has any parental rights There is no home study, there's no background checks, there's no criminal clearance, there's no even a hearing before a judge. You just meet those 3 criteria, and New Jersey will issue you an adoption judgment saying that both of you are the parents.
Okay, would you offer any advice to married gay couples traveling out of the country just on vacation? Should they be carrying specific documents with them internationally? Again,
Yes, everyone should be carrying all these things on their devices. And, I have a client who has father lives in Greece, and she was going to Greece with her 3 children and going through immigration. And they said, well, where's the dad? And she pulled up her judgments of adoption for each of the 3 children, and she sailed through.
Mm.
Adoption is recognized worldwide. Everyone knows what an adoption is. As distasteful it may be that you had to adopt your own child, it's better term to use.
Okay. And it seems like the last question, and I think it's a little bit of a reiteration of things that we've already discussed. If I move to a different state, do I need to have my will and/or trust redone?
Well, I let Bill opine on this. I want to mention something about trust, but wills, yes, I think you should, because the laws are different in every state. The one thing I want to mention with trusts is that, and I can specifically speak for New York, if you set up a trust in New York, and you are a New York resident and you relocate, it's still a New York trust. You don't lose that New York residency. So there are certain things you can do with trusts. You can do some decanting, which means you move assets from one trust to another. So you can play with it a little bit, but just keep in mind that relocating just doesn't undo all of those residency ties.
And just to follow up on what Mary said, a will executed under the laws of the state where you are a resident will be recognized in another state. So it's not like, you move and all of a sudden you don't have a will. The thing you got to do is meet with an attorney or an advisor in the new state to make sure that your will meets the requirements, not the statutory requirements of being a will, but looking at it from a tax point of view and other financial point of view, whether it's adequate in the new state.
Excellent. Well, that was our last question. So I want to take this moment to thank all of our panelists for the wealth of information you provided today. Really, as a member of the community, I feel like I've learned a lot, and I'm ready to go home and talk to my fiance and say, we got to get moving. We got to get some stuff in order. And thank you to everyone who joined today. We hope you learned something and that you have the information you need to take the proper steps to protect your families and preserve your wealth. And again, we will be sending out a recording of the webinar so you could access this at your leisure. And if you do have any questions for our panelists, in that follow-up email with the recording, we will make sure to include everyone's contact information so you could reach out to each one of them directly and ask those questions. Again, we are here to serve our clients and prospective clients. So if you have a question, do not hesitate to reach out to any of the folks on this webinar. So thank you all. And with that, I wish you all a wonderful rest of the day and a very, hopefully in the Northeast, a sunnier weekend than we have right now. All right, everybody. Thank you so much.
Bye.
Thank you, everyone.